Someone else? Yeah.
That's the other document.
Before this judge even starts asking questions, you need to understand just how serious this bond hearing is. This is not a routine check-in. This is a defendant who is already facing a $250,000 bond for aggravated assault involving a firearm, and then allegedly committed another violent crime while out on that bond. Judges don't see this every day, and when they do, alarms go off fast. Bond isn't about punishment. It's about public safety, court compliance, and risk. And in this case, the court is clearly asking one question. Is this defendant capable of following any conditions at all? Because what you're about to hear involves guns, repeat offenses, ankle monitors, social media evidence, and a bond that didn't deter behavior. It allegedly escalated it. Stay locked in, because this hearing turns from confusion to concern to a complete bond revocation that changes everything.
Who did?
No,
No, who paid it? You? That's $25,000. I guess did she win the lottery or something?
my mom was silence.
It's five, so she posted 50,000. Okay. There's a motion to increase the bond. Well, here's the.
This is where bond law starts to matter. The judge is clearly frustrated, and for good reason. The defendant had already posted a $250,000 bond, meaning someone, in this case his mother, paid a significant amount to get him released. Then the court learns he's back in custody again. That raises immediate red flags. Bond is not meant to be recycled over and over while new violent charges stack up. The judge is trying to understand whether increasing bond even makes sense if the defendant continues to reoffend. And notice the emotional undercurrent here. The court points out that the bond money, tens of thousands of dollars, is gone. Lost. That doesn't seem to register with the defendant at all. And that reaction matters. Judges look for concern, accountability, awareness. When none of that shows up, courts start asking a much bigger question. Is any amount of money enough to protect the public?
And there was a bond set of, it looks like $250,000 was the bond on July 24th when you were arrested for this indictment. Then afterwards, about a month later in August, a couple of weeks ago, it is alleged you committed aggravated robbery and your bond was set at $500,000. So he's got a $250,000 bond and now a new $500,000 bond. Is that right?
That's correct.
Okay. And August 25th. Have you seen this probable cause affidavit?
I just got it today. Yes, I just got it today, Judge. With the motion to increase the bond.
Who set the bond on this one? Does it, I guess, a magistrate?
The 500 or the
Yeah.
50?
The new one, the 500,000.
The 500 was set by Judge Jerome.
Okay. So on this first bond, the indictment for aggravated assault, the court has reviewed the probable cause affidavit, which states that on July 19th, Beaumont police responded to East X Freeway in reference to a victim of a shooting, and the victim was suffering from multiple gunshot wounds to his lower extremities of his body. And Uh, the defendant in this case, Christopher Harris, it's alleged the defendant entered an unlocked apartment, produced a handgun, fired 6 shots at Albritton, causing serious bodily injury, and then fled the scene. So, shot somebody several times and then fled. And so a $250,000 bond was set in that case. So, just a few weeks later, and it looks like we're talking about 5 weeks later, on August 25th, 2025, after the defendant had posted a $250,000 bond, police responded in Beaumont to an aggravated robbery and spoke to the victim, who stated he was robbed at gunpoint by 3 black males who stole his belongings as well as his Lincoln Navigator vehicle. And police located quickly the stolen vehicle at Cardinal Oaks Apartments here in Beaumont with the lights on and the engine running. And observed someone named Arthur Gouldsby standing in the driver doorway with the driver's door open. He was transported to the station, confessed to his involvement in the robbery, and stated that he, along with Harris and Brandon Johnson, the defendant Harris and Brandon Johnson, who were armed with handguns, lured Wilson to pick them up under the premise of going to a party. Once they directed him to a secluded area, Johnson asked Wilson if he could drive the vehicle. Wilson pulled over, at which time Johnson and Harris pulled guns on Wilson, stole his silver necklace, watch, cash, and told him to run. Johnson shot at Wilson as he was running away. Who does that? I mean, you got them. You have 3 people at gunpoint and then steal everything, tell them to run and then shoot us. Yeah, it was. Johnson shot at Wilson as he was running away. They all fled in the victim's stolen vehicle. The defendant had an ankle monitor because of his last event, so he wasn't hard to find. And they were able to track his movements and put him in the vehicle at the time of the robbery at the robbery location. Who does that? You know, when you've got an ankle monitor and you're going to be tracked, why would you be around some place that causes trouble? And we'll put him right at the location at the time of the robbery. And so
this is the turning point of the hearing. The court lays out the timeline: a shooting, then an aggravated robbery weeks later, allegedly committed while wearing an ankle monitor. That detail alone is staggering. An ankle monitor exists for one reason: to deter and track. And yet, according to the record, it placed the defendant directly at the scene of another violent crime. Add to that co-defendant confessions, gun use, a fleeing victim being shot at, and then social media evidence showing stolen jewelry being worn afterward. Judges rarely react verbally, but here, even the court asks, who does that? That's not sarcasm. That's disbelief. So here's the question for viewers. If high bonds, monitoring, and supervision fail to stop violent behavior, what options does the court realistically have left?
The state said that it did make a $250,000 bond. So in essence, Judge, that bond has already been doubled to the $500,000, which he has not made. So I'm asking the court to keep both cases at the 500,000 because that's already been doubled and that's something that he has not made and it's doubling what he did make. So
Right.
I'm just asked to keep it at that 500,000.
Anything, statements?
Your Honor, we're just asking for the other one is at 500,000. We would just ask for the 900,000 on there because of the nature of the offense after he just committed the very serious aggravated assault, and then gets out and does this aggravated robbery, again shooting at an individual not much later from when the other, I think within a month.
Did you look into it?
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer. Is that what you want? No. That would be wise. Anything else? Okay. The court finds as follows. $250,000 bond was set in this first case of aggravated assault, use of a deadly weapon. And not only was $250,000 set, but the defendant was required to have a tracking device. What were the other conditions of bond? Were there any other conditions that it shows? Because I don't have a lot of.
No contact with complaining with witness remain in Jefferson County and to testify.
Okay. So just a few weeks later, I'm sorry, this was on or about July 19th is the indictment date. And he was arrested on or about July 24th for that first robbery that he was indicted for, and then posts his bond for $250,000. 1 month later, approximately 4 weeks later, August 25th, here in Jefferson County, Texas, the defendant commits another similar robbery, a aggravated crime using a deadly weapon, where defendant and others robbed the victim, and the court finds that the first court's conditions of bond were pretty serious, and in spite of that, the defendant defied logic that he would be placed at the scene of a crime if he commits a crime because of the monitoring of the ankle. So it's obvious that the conditions of bond that were set, a high bond amount, and ankle monitoring him did not deter him from committing a more violent crime. So he is in custody and there is no bond. The court finds that there are no reasonable conditions that can protect this community from these bizarre, violent crime need, and for the protection of the people and to see that the Constitution works so that we can live in peace. The defendant needs to be sequestered in jail because of his propensity to commit violent crimes with firearms, including robberies, and aggravated assaults. So there is no bond, and his bond is revoked on the $250,000 bond that was paid originally. That is revoked. That is lost unfortunately to his mother, who posted that bond, but that's the way the rules are. ironically, you don't seem, you don't seem too upset, but there are victims in two different situations, but there's also a victim here, your own mother, that you victimized by your actions. You don't seem too upset. I would be. I think that's just normal behavior. But there is no bond, sadly, for your poor actions, and we will set this for trial. Okay, all right. That is all.
This hearing ends with one of the strongest bond rulings a court can make. No bond at all. The judge makes it clear there are no reasonable conditions that can protect the community. High bond failed. Ankle monitoring failed. Court supervision failed. And when public safety is at stake, constitutional law allows detention without bond. The ruling also highlights another overlooked victim, the defendant's own mother, who lost the bond money trying to help him. This wasn't just about punishment. It was about preventing further violence. And the court didn't hesitate. Back-end index pointing right if you found this case intense, disturbing, or eye-opening. Hit that like button, share your thoughts respectfully in the comments, and subscribe for more real courtroom breakdowns where actions meet consequences.